Well, good morning, everyone. Welcome to this morning's webinar. I'm George Spees with the Office of Open Records, and I'm going to be talking about the right to know law for law enforcement this morning. A couple of preliminaries as we're getting started here. First, if you've ever attended one of these webinars before, you know that it's essentially a PowerPoint presentation with me talking in the background. The PowerPoint is available on our website. You go to the training tab and scroll down, and you can find all of the PowerPoints that we use for our training, and you're welcome to use any of them. Perhaps you have a coworker who couldn't attend this morning, and it might be a good reference. You might want it for your own reference for future use. Or maybe you're conducting localized training and you need some resources. Well, feel free to download these PowerPoints and use them as you need. Excuse me. The other thing is that this session is being recorded, and the recordings are also available on the website. It takes a couple days because they get processed and uploaded to our YouTube channel, and then a link from the YouTube channel to the website, et cetera, et cetera. But in a couple days, this recording will be posted on the website, again, for the same reasons. Maybe you'd like to refer back to it for your own educational purposes. Maybe you have some coworkers who would benefit, or you want to use it for localized training. Again, feel free to go for it. We consider them public records, and you're welcome to use them as you see fit. Okay, and then there's something new that I just wanted to let you all know about. If you sat through some of the other courses, occasionally I will refer to the Office of Open Records as a court. And, that's a fairly accurate statement when it comes to how we deal with appeals. And this has been an issue since the office was created, that there's a lot of work. There's a lot of volume. The appeals are in the thousands. So it's really important to keep track of all that. And from the start, we've done our best to use computer systems just to stay organized. And the appeals officers in our office will use this docketing system that we have in order to keep all the case files organized, both for themselves and for senior management. And if you were to, for instance, if you were to call into our office with questions about an appeal that you're working on, whether you're the person who filed the appeal or the agency that's defending itself against the appeal, if you have, the name of the municipality or your name or the docket number, something like that, the administrative staff can look up the latest information on that appeal and let you know what's going on. Well, now, starting in July 31st, we've developed a portal that will allow those people participating in an appeal to access all the same documents that the appeals officer has access to. So, if you don't want to call, if you just want to, sit in your office or your family room or whatever, we will issue you a password. And then you log into our system using that password, and you'll have access to all of your documents related to your appeal. So you can stay just as organized and be just as informed as the appeals officers. No need to call in, but you still can if you want to. But it's just another neat feature that our office is using to allow all the users to have access to the information that you're entitled to. So look for that starting July 31st. There's going to be more information posted on the website, on the blog, not Facebook, but on probably the Twitter account and so forth and so on, to let you know what's going on, how to gain access. I think there's going to be some training courses online, but it's going to be a really cool feature that you'll find, there are some courts, some of the county courts, Commonwealth Court, Supreme Court, using these docketing portals as well. And we think it's going to be very helpful for everybody. So all that said, let's jump into the topic today, which is really why you're here, the right to know law for law enforcement. Now, the purpose of this course is to kind of pare down all the information about the right to know law to those points that are particularly germane for those people working in the law enforcement community, police departments, district attorneys, and the like. There's a lot to know about the right to know law. And if you sat through some of the courses, yeah, you're aware of that. But for law enforcement, we realize, you're busy. We don't expect you to be experts on the right to know law per se, with everything else that you have going on. But there are some things that you do need to be aware of. So that's what we hope to get, across to you in the next hour, so that when you do get a right to know request, you have some good information that can help get you started and maybe even get you through the entire process with making a good decision as to what records you can release, what records maybe you should be withholding. Okay, so let's jump into it here. And I want to begin by talking about, just why the right to know law is important. So let me put out a fundamental statement here, in that the purpose of Pennsylvania's right to know law is to give the public access to public records. Okay, seems fairly basic, but yet I'm always surprised at the amount of misunderstanding that there is on both sides of the equation as to what the right to know law really is about. I think part of it is people see that term right to know, and they think that this is some sort of Google mechanism for state and local government. And it's not. I just want to say that if you're working for an agency and you have a right to know request that you're processing, and, maybe it's not written as clearly as you'd like, maybe you've, encountered some records where, it just isn't necessarily clear as to whether these are public or not. Excuse me, I got a cough here. Oh, sorry about that. Or, maybe you're just not sure what direction to take with processing the right to know request that you've received. What I recommend is always come back to this fundamental statement. It's the agency's job to provide public records. No more, no less, okay? Occasionally you will see a right to know request where people are going beyond that. They're asking questions. They want to talk to somebody. They want to see something that, doesn't necessarily represent a record. And it can be confusing and daunting at times. If you come back to this fundamental statement, a lot of times it can get you back on track, headed in the right direction, making the right decisions, and resolving the right to know request in an appropriate manner. But we need to keep in mind that under the right to know law, our starting point is that every record of an agency is presumed to be public. Okay, now that can be a rather daunting statement. There are some people who, they hear about this for the first time and they think, oh my gosh, everything in the office is going to be on someone's Facebook page tomorrow, or, it's going to be on the front page of the newspaper. And that's not the case. And you'll see as we go through this presentation today that there are several protections built into the right to know law that if a record truly is or should be considered confidential or sensitive in some way, that the right to know law provides tools that allow you to withhold those records. Okay. Sometimes you get a right to know request for a record and you think, a red flag goes up in your head. It's like, I just don't feel comfortable with the idea of releasing this. Chances are one of those tools is available in the right to know law to support that suspicion that you have. But we need to take a look at what those tools are to make sure you're on the right track. The other thing is that agencies bear the burden of proving that a record is not public. Okay, so our starting point, every record is presumed to be public. But if an agency believes that the record should not be released into the public domain and chooses to use one of those tools available through the right to know law or another confidentiality law, that the agency bears the burden. You have to make a legal case to prove why this record should not be released into the public domain. Again, It sounds rather daunting, but as we go through the presentation, particularly this one for law enforcement, because I think, if anything, the right to know law is very sensitive to law enforcement and the need to keep records confidential. So if you're aware of what those tools are, chances are you'll be able to withhold those records that you're concerned about. Okay, so that being said, let's jump into some of the specifics. Your department, your law enforcement agency, is subject to the right to know law. So there are some things that you need to do. Probably the first and most important is to appoint an agency open records officer, what we call an AORO. Some folks call them right to know officers. It's the same thing. There's no difference. All right. This can be uniformed or non-uniformed personnel. It could be, let's say you work for a borough and you've got an AORO who's responsible for everything. Okay, Public Works, HR, as well as the police department. Okay, that's okay. You can do that. Or let's say you have two AOROs, one who handles the administrative office, and then the other who handles just the police department. That's okay too, as long as it's clear to the public who they should give their right to know request to. Okay, you need to educate the public as they're working their way through this process. So for the agency open records officer, you have to post the contact information. This needs to be physically within your office. If you have a website, it also needs to be on your website. Who's the AORO? Okay, then you need to have a form available so that if the person doesn't have a right to know request form and they are required to have one per your local regulations, you need to have a blank form available for them to use. Then you have to have the applicable appeals information so that if you do end up denying their right to know request, they know what the next step is. Typically, well, for law enforcement, it's a little different. It could be that they file their appeal with the Office of Open Records, or it could be with the local district attorney. It just depends on what basis you use for denying your request. And we'll get into that as the presentation proceeds here. Then you need to instruct all your staff, uniformed and non-uniformed, that if someone hands them a right to know request, they need to get it to the AORO as quickly as possible. There are hard deadlines built into this law, no wiggle room, okay? So that the clock may start ticking depending on the circumstances. And if, let's say, it's given to some administrative staff, if they waste time, or if they just put it in an outbox thinking, well, I'll get this to the AORO downtown here when I'm making my trip next week, that could be a problem. All right, so you want to make sure all staff forward the right to know requests to the appropriate person, the agency open records officer, as soon as possible. There should be some mechanism in place to allow them to do that. And then finally, we ask that you let us know here at the Office of Open Records who your AOROs are. We have on our website a database of AOROs statewide. The public can refer to it. As well, we use it here that if we get an appeal, this is the person we reach out to. So we realize, this changes. People retire, they move on, they get promoted. So one of the takeaways today is maybe you want to check our website to make sure that the contact information for your AORO is up to date. If not, there's a form there you can fill out, email it to us at the address on the form. We'll verify it, and then we'll update the database so that everything is accurate. Okay. Now, some things that you can't do under the right to know law. The first is that you can't limit the number of records that a person requests or the number of right to know requests that a person puts in during a specified time frame. You can't say, ma'am, I'm sorry, but you already filed 3 requests this week. That's all we allow. If she wants to file a dozen right to know requests, that's legal. She can do that. The other thing that you can't do is force a person to tell you why they are filing a right to know request. You can't deny a request based on the reason or what you think that reason might be. Now, let me go off script a little bit and just say that the majority of people who file right to know requests have a legitimate reason for doing so. But there are those people who, for whatever reason, the relationship between your department and that person is broken down. They've decided they're going to be a pain in the neck, and one of the ways they're going to do that is to weaponize the right to know law and file a bunch of frivolous requests. What I recommend is sit in on our webinar where we talk about the payment side of the right to know law, because there I get into specifics about how you can deal with these problem requesters, okay? Or feel free to call our office and we'll provide some advice there. And if you're attending today and you are one of those problem requesters, well, shame on you, okay? Please stop it. So we've got these prohibitions that you can't do. It's not the end of the world, okay, when you're dealing with people who file a lot of requests. There are ways around it, but also, like I said, people file legitimate requests most of the time. It may simply be a matter of talking to them to narrow down the request to identify the documents that they need. Moving on. I like to describe the right to know process as an obstacle course. This obstacle course has a start, which is receiving the requests. Then we have to consider the deadlines, which are similar to time standards built into certain competitions. This obstacle course has 2 hurdles. And in front of the second hurdle, there are 3 hoops. We're going to talk about all these real quick. Okay. And it's only after you make it over the second hurdle that you've determined it's a public record and you're granting the request. Okay. So let's run through this. First offhand, when you receive a request, well, let's talk about the deadlines. When you receive a request, the clock starts ticking, okay? And the initial deadline is 5 of your business days. Now, as a law enforcement agency, chances are you are a 24/7 operation. So you take a look at the administrative side of the operation, and when is your administrative office open to conduct public business? Typically, it's a Monday through Friday operation. You wouldn't count Saturday and Sunday. If you're closed for a holiday, that would not be considered a business day. If you're closed for a weather emergency, like, maybe there's storms, flooding, snow, or whatever, that's not considered a business day. Okay, so that's how you would count your 5 business days. At the end, the close of business at the end of the 5th business day, that's when that first deadline is due, okay? And you should provide an initial response by that 5th business day. Now, let's say that you're unable to do that. The right to know law then allows you to invoke unilaterally a 30 calendar day extension. But there are some conditions in order for this extension to be considered valid. First is you have to invoke it within that initial 5 business day window. You can't wait until what would otherwise be the 6th business day, say, oh, I forgot about this right to know request. Well, we'll just take the extension. Unfortunately, at the end of that 5th business day, when you missed your deadline, you denied it by default. Legally, it's what we call a deemed denial. You'll hear that phrase if you get into the appeals process. So you want to do it within the 5 business day window. You have to respond back to the requester in writing that you're taking the extension. And if the process is such that they submitted it by email, you can write to them back using email. You have to provide the reason why you're taking the extension. You go to section 902 of the law and it lists 6 reasons. And you just simply pick the ones that apply. We keep these records off site. It's going to take us longer than 5 days to go through and figure out what's public and what's not. Or our solicitor wants to review our response to make sure we're not giving out anything we're not supposed to. Something like that, okay? All common sense answers that make perfect sense. Just don't get into the habit of automatically invoking the extension uh, when you don't have to. If the right to know request is for what clearly is a public record and it's readily available, grant the request within the 5 business days and deal with it. Nothing upsets people more than to request what is obviously a public record, and the first communication that they get back is, oh, we're taking a 30-day extension. All right, if you don't have to do it, please don't. So you've got the 5 business days and then the 30 calendar days tacked on to the end of it, available for responding to the request. Then let's say you end up denying the request. There is a 15 business day appeal period that the requester has to file the appeal with the Pennsylvania Office of Open Records or with the local county district attorney, if that's the case. And at this point, it's 15 business days for the Office of Open Records or the county district attorney, not the way that the law enforcement agency counts their business days, but rather how we count our business days at that point, which could be a factor if you are a part-time police department or provide part-time coverage. Okay, now we're up to the first hurdle, and here we have to answer the question, is it a record that the person is requesting? And what I tell people, whenever you're trying to understand a law, okay, you can read through the law and, sometimes it's written in a lot of legalese, okay? It's not written in common English. And you may come across passages where it's somewhat vague. There may be provisions that appear to conflict with each other. Always take a look at the definition section of the law, okay? And the right to know law is no exception, because when it uses the term record, that actually means something. Sure enough, you go to the definition section and it defines what a record is, okay? So remember our exercise here. We're answering the question, is it a record? So we go to the definition section and we find that a record is any information, regardless of its physical form or character, that documents a transaction or activity of an agency and is, et cetera, et cetera. Key phrase highlighted here, folks, documents a transaction or activity of an agency. All right, what does that mean? Common English, it basically means that a record refers to the work being done by the police department, by the law enforcement agency. So you're thinking, why would we have anything that isn't a record then? Well, think about it. All day long, we generate communications that probably don't rise to the definition of a record. I send an email to a coworker. Hey, you hear about the restaurant that opened up downtown? You want to meet for lunch tomorrow? Or what do you think of the Phillies' chances going into the end of the season here? How do you think they're going to do? Or, hey, I'm picking up a pizza on the way home tonight. All right, all fairly common communications, but none of those have anything to do with the mission or the work being done by our police department. Well, guess what? Those communications are not considered records under the right to know law. So if someone were to submit a right to know request for all of my emails, they're off the course. They don't make it over this first hurdle because they do not rise to the definition of a record. Okay, now I think it's important for me to change this around a little bit. Let's say I use my personal cell phone and I send a text message or an email to one of my coworkers. Hey, can you send me the interview notes for this particular case that we happen to be working on? All right. Now, that communication is considered a record because I'm talking about some work of our department, part of its mission. But you're saying, wait a minute, I did it on my personal cell phone. Well, that doesn't matter. It's the content of the message that determines whether it's a record, not how the message is created, how it was sent, or where the message is stored. If the message is generated by an officer of the department, or, for that matter, it could be plain or civilian. As long as it deals with the work of the department, it's considered a record and is accessible under the right to know law. One of the very first decisions out of the Pennsylvania Supreme Court related to the right to know law is that you cannot use personal devices and personal accounts to hide the public's business. All right, so keep that in mind if you are using personal devices to conduct work business. There's nothing wrong with it. There's nothing illegal with doing that. Just keep in mind, though, that those messages are accessible under the right to know law because they are defined as records. All right, moving on now. We're coming up. Oh, yeah, let me talk about this. The other part of that definition is any information, regardless of its physical form or character. So, yeah, we're talking about paper records, electronic records, which could be emails, phone records, text messages, Word documents, Excel spreadsheets, various database applications, all right? Any physical form or character. Audio recordings, we're going to talk about that. Security camera footage, we're going to talk about that in the context of Act 22, which is the next slide. But I do want to touch on social media. Let's say your department has a Facebook page. Okay, keep in mind that usually any record that gets posted to Facebook is considered a public record. And the question has come up, well, what if that record has been deleted? What if we took it down? All right, and we've had some case law on this. And the bottom line is that if it's on the internet, usually it never goes away. So it's there, and Facebook is no exception. It's not hard to retrieve deleted records through Facebook. So if you get a right to know request for records on a social media, whether it be a web page, Facebook account, Twitter, whatever means you're using, just keep in mind that those are usually considered public records and you'll need to provide them. Now, what if it's still up on your website or Facebook? The right to know law allows you to respond back in saying that is a public record, but it's on our website. Here's the link to the website, or it's on our Facebook page. Here's the link to the Facebook page. And that's all you have to do. You don't have to print out any records to provide them because it's already out there in the public domain. The other thing to keep in mind about deleted records are phone records. Sometimes you'll get a right to know request for a record of all phone calls. With cell phones, that's somewhat problematic, okay? Because if you've deleted your call log off the cell phone, there's a good chance that it isn't there anymore, okay? And that those records cannot be retrieved. But under the right to know law and case law, you're still required to conduct a good faith search. So that good faith search entails contacting the cell phone provider. Now, under a federal statute, they do retain the records, okay? They do have them, but they're going to tell you, we'll provide them when you give us a subpoena. Under the right to know law, you're not required to get a subpoena to retrieve otherwise deleted records. So you've met the test of your good faith search by simply calling the cell phone provider, asking for the records. They say, we need a subpoena. Since under the right to know law, you don't need a subpoena, you've done your due diligence, okay? You've done what's been required of you under the right to know law. If by chance they happen to say, yeah, we'll provide them without a subpoena, well, then you typically end up providing them under the right to know law. The problem is under the right to know law and the constitutional right to privacy, you can withhold personal phone numbers. So what becomes at issue is distinguishing business numbers from personal numbers. And how you do that, I've yet to find an answer. Sometimes you know the number by heart or whatever, but that's a problem that Fortunately, doesn't come up all that often. All right, so that's kind of the spiel on what is a record under the right to know law. Okay, now I want to talk about dash cam, body cam, and security footage. It used to be that this was all accessed under the right to know law. But then back in, gosh, I think it was 2017, the legislature passed Act 22 in response to outcry from law enforcement because it was just becoming too burdensome to provide this footage. So now, if someone wants copies of the footage from a dash cam, body camera, or a security camera, in certain cases, they use Act 22. All right. And the best resource for finding out about Act 22 is the Pennsylvania State Police. Okay. They have a page on their website that kind of explains it. We also have a page on our website because when this first came out, there was no guidance. And even though the Office of Open Records is no longer involved in the process, we were getting all kinds of questions. So we put up a page on our website explaining it. But the bottom line is you go through directly through the police department, not through the Office of Open Records to get this footage, okay? We're no longer part of the process. But Act 22 basically says you can request the footage within 60 days. After 60 days, you can no longer get it. The police department now must respond within 30 days as to whether they're granting the request or not. And the police department can charge reasonable fees above and beyond the right to know law fee schedule. Okay, the right to know law fee schedule doesn't apply. So you can charge for labor, which, under the right to know law, you can't. But under Act 22, you can. All right. And then if the police department denies access to the footage, the appeal goes directly to either the local court of common pleas for a local police department or the Commonwealth Court for the Pennsylvania State Police. Okay. Again, the Office of Open Records is not involved in the appeal process. Now, I mentioned security cameras, okay, because this is an important distinction. Let's say that the police department and the borough offices or the township offices are all in the same building, and there's a camera that covers the front parking lot. Now, if the monitor and the recording equipment for that camera go to the administrative, the non-law enforcement side of the jurisdiction, the municipality, the right to know law applies for getting that footage. If, however, the monitor and the recording equipment are on the police department side, even though it's the same camera, then it's Act 22. It depends who owns the footage. Is it non-law enforcement or law enforcement? Non-law enforcement, right to know law, right to know request. Law enforcement, Act 22. Okay, so that's the distinction. I also should mention that under Act 22 with security cameras, the definition of a law enforcement agency is much broader. For instance, you could have a school district with a law enforcement officer, what they call a resource officer, that if that person is certified as a law enforcement officer, then the school district is considered a law enforcement agency. Okay. It's a little absurd, but that's how the law is written. And until it gets updated and changed, that's what we've got. You've got school districts out there, private charter schools, considered law enforcement agencies under Act 22. All right, just food for thought there as we move through the presentation, because there's another law that we need to keep in mind as to what a law enforcement agency is. Okay, so now we're up to the second hurdle. And remember, we've got these three hoops that we've got to make it through before we can make it over the second hurdle. And the gist of this second hurdle is we've got to answer the question, is it a public record? Notice the distinction. First hurdle, is it a record? Now we've got to determine, is it a public record? And in order to do so, we've got to make it through these 3 hoops on the obstacle course. So the first hoop is we take a look at and answer the question, are there any exemptions that apply? And if so, are we going to invoke them? All right, so what's an exemption? Well, you go to section 708B of the law, and there are 30 exemptions that define types of records that if it falls into one of these exemptions, the agency can release it if it wants to. Okay, the agency has the discretion to either withhold the record because the exemption applies, or they can release it if they think it's in the public interest to do so. All right, now there are 3 exemptions for law enforcement that we're going to be talking about here shortly. Okay, 3 out of the 30. Maybe some of the other 30 apply, but these are the 3 that you should be familiar with. Then we have to answer the question, are there any federal or state statutes or a judge's order that make these records non-public? This is important for law enforcement because in Pennsylvania, we also deal with a law called CREA, the Criminal History Records Information Act. Okay, and CREA is a law that defines a body of records that can only be shared with other law enforcement agencies. Okay, now there's some overlap with the right to know law. For instance, the right to know law says you can withhold investigatory records. So does the CREA. But if you take a look at the right to know law, there's nothing in there about intelligence information. Whereas if you look at CREA, there is. Okay, now what if I get a right to know request for intelligence information that's held by the police department and I need to deny it? Well, because I can't find a reference to it in the right to know law, I now go to CREA, where it does specifically reference police intelligence information. So I use CREA as the basis for denying the right to know request, because CREA says I can only share this within the law enforcement community. Okay, so CREA removes the discretion that the right to know law would otherwise give you. Remember, the right to know law says I can release it if I think it's in the public interest. CREA says, no, you must withhold intelligence information. And if there is another law that says you must withhold these records, that trumps the right to know law. Okay, you cannot release it because CREA makes it illegal to do so. And we refer to this in section 306 of the right to know law, which basically says the right to know law defers to any other law that says a record is confidential. Okay, now, what about those law enforcement agencies, though? Remember when we talked about school districts in Act 22, which is kind of bizarre? Well, we come to CREA, and CREA says it defines a law. Remember what I said about going to the definition section? We go to the definition sections of CREA, and it defines what a law enforcement agency is. And that definition is much narrower. Only certified law enforcement agencies. You can only share these records with other certified law enforcement agencies. Okay, you can't even share these with the Office of Open Records. That's been tested in court. We had a case where we determined that the best way to figure out whether these records are public or not is to order an in-camera review, which is a legal term for saying, give us the records so we can take a look at them. The law enforcement agency invoked CREA. They said, no, we can't share those with the Office of Open Records because you're not a law enforcement agency. It went to court, and the court agreed with the police department. You can't even share it with the OOR. And we agreed too, but we felt it was good to have this case law in place just in case there are any questions about this. Okay, so then we come to the third hoop as part of this exercise. Is the record protected by privilege? Here we're talking about attorney-client privilege, all right? This would be communication with your solicitor that involves sensitive information, legal advice, legal guidance, that sort of stuff. In Pennsylvania, under the rules of evidence, anything protected by attorney-client privilege is considered confidential, and you can invoke attorney-client privilege as your legal basis for withholding records from the public. Okay, and again, this is referred to in the right to know law. Go to section 305 and you'll see attorney-client privilege records are considered confidential. Let me get a quick sip of coffee here and we'll move on. All righty. Now, those 3 exemptions that I referred to earlier, 3 out of 30. If you're on the law enforcement side, this is the important slide. This is what you need to be aware of. First offhand, criminal investigatory records that are covered by section 708B16. Now, these would be any records critical to a criminal investigation. Case notes, interview notes, any sort of analysis that's done, any sort of communication related to the investigation of a crime or suspected crime. Okay, there doesn't have to be a conviction. There's no statute of limitations. Okay, these can be 20-year-old cold case files. In Pennsylvania, as long as they're considered investigatory records, they can be withheld from public disclosure. Now, it does not include what's known as blotter information. If you're not familiar with this term, a police blotter is basically a diary of shift activity. So if there was, a dispatch of an officer to a specific address during a shift, the blotter information can be given out. Okay, it's some people call them incident logs. There are other terms that are used, but basically it's like a shift diary or an incident log. But incident reports, okay, and this would be essentially a summary. It's not the case log, it's not the blotter, but it's the summary of the specific incident. Okay, there's a difference between an incident report and an investigatory report, but incident reports are considered investigatory by their very nature. And I believe it's the Pennsylvania Commonwealth Court issued a decision that because incident reports are considered investigatory, they can be withheld using the B16 exemption. Okay, now let me repeat this in the simplest of terms. Incident reports are not considered public records, and they can be withheld. Now, some departments will still release incident reports, especially to the media, but they'll scrub out any sensitive information, any investigatory information, and release those incident reports. But the bottom line is that incident reports are not considered public records. Okay, now let's move on to non-criminal investigatory records, which are covered by 708B17. That's the name of the exemption. Okay, let's say you're a small department in a small municipality, and while there's a police presence, there's no code enforcement authority. Well, someone calls in complaining about the condition of their neighbor's yard, and you guessed it, who gets sent? Okay, well, there's no crime that's necessarily been committed. It's just this guy hasn't mowed his lawn in a month or so. All right, so the neighbor's complaining. It's considered, they view it as a hazard or whatever. So they send a police officer out to investigate. So it's a non-criminal investigation. Well, any record of that investigation, including the name of the person who called filing the complaint, can be withheld from public disclosure using this exemption. Okay, so any non-criminal investigation. Another example, sometimes an apparent suicide. Okay, you get the call, you show up at the scene, and it's obvious that the person took their own life, and there's no criminal activity that has occurred. Just given what you observe at the scene, there's a note, et cetera, okay? No charges are filed. There's no, like I said, no criminal element as part of this investigation, a non-criminal investigation. So because, let's say, that note is there, if you receive a right to know request for it, you can withhold that note based on this exemption. Okay, another example. All right, and then the final one that we should take a look at is 708B18. And this would be any record of communication with the emergency dispatch, the 911 center, or if you're locally dispatched, that local dispatch as well. This would be like phone recordings of people calling into 911, recordings of any communication back and forth with the police department, whether it be, their portable or their vehicle radio. All of that is considered confidential using the 708B18 exemption. I'm going to say of the 30 exemptions within the right to know law, and they've all been tested, there's all case law available for this, 708B18 is probably the tightest one written. Okay, it does not allow you to release recordings of these phone calls or radio transmissions. But you're thinking, wait a minute, George, I've heard these. I've heard these on TV and on the radio. Well, there is a provision that allows the emergency management administrator, the EMA, to release these if they believe it's in the public interest to do so. And occasionally they will. They'll think, okay, maybe this will help solve a crime or prevent future crimes, or perhaps it's just in the public interest to release this recording. So we can do that, okay? But it's very tight. It's only at their discretion and when it's in the public interest to do so. All right, so I think that pretty well covers it, and there haven't been any questions so far. So I think either I'm doing a great job or I bored you to tears and you've fallen asleep. But if you do have questions, feel free to type them in the chat feature and I'll do my best to answer them as we're going through here. Okay, moving on. Let's talk about the appeals, okay, because I've mentioned this. Most appeals filed under the right to know law come to the Office of Open Records, except if you have a law enforcement agency who has denied the right to know request based on the B16 exemption. The law enforcement agency is saying, no, we're not going to let you have these because these are part of a criminal investigation. Okay, and then you issue your denial letter. Well, under the right to know law, those appeals, if you're a local law enforcement agency, go to the county district attorney. Okay, and they will have either a deputy or an assistant DA who is assigned as the appeals officer, and they will determine whether or not the police department is appropriate in their denial by saying these are investigatory records. All right, question has popped up. Is the 30-day response period for Act 22 30 calendar days or 30 business days? Nathaniel, I don't know. And I honestly don't think it's ever legally been tested. Usually, if it doesn't specify business days, it defers to calendar days. And I would have to go back and read Act 22, which I haven't done for a couple years, to determine whether or not it specifies that. So if it just says days, it's calendar days. But if it specifically says business days, then that's what it is. Okay, and it would probably be business days of the department. So take a look at our page to see, there's probably a copy of the law there, and you can determine that. If not, go to the state police's page, and they'll probably have it there. The issue is that there just isn't a lot of case law on Act 22. So it's clear with the right to know law, but probably not clear with Act 22. And I'm racking my brain here trying to remember, and I just don't, because I just haven't read Act 22 for several years, but it's there, Nathaniel. You'll find it, and that's the guidance you'll need to use there to determine it. Good question. Okay, so back to appeals. It's 15 business days to file the appeal with the county district attorney. And like I said, they'll have either an assistant or a deputy DA who functions as their appeals officer. And they will issue written decisions as well. And probably about 2 years ago, we started keeping track of those and putting copies of their written decisions on our website. So you can search our website for their decisions for when they do respond to these denials and appeals that have been filed because of using B16. Okay, let's talk about costs of the right to know law, because this will come up with law enforcement agencies. General rule of thumb is that for hard copy records, when you provide them, you can charge up to 25 cents a page for 8.5 by 11 or 8.5 by 14, single-sided black and white. If you're providing electronic records, like those emails or Word documents or whatever, you cannot charge for electronic records. Everything else is actual cost. So that, let's say you're providing paper records and you're mailing them out, well, you can add the cost of postage to your fees. There's no cost for labor or redaction. Under the right to know law, you cannot charge for the time it takes you to prepare the response. It's simply considered the cost of doing business under the right to know law. Now, here's an important one. If you're providing records under another law, any of those legislated fee structures take precedent over the fee schedule for the right to know law. The example are accident reports. Okay, someone submits a right to know request and they want a copy of an accident report. Okay, well, under the right to know law, you can charge 25 cents a page. But if you take a look at the motor vehicle law in Pennsylvania, it allows you to charge $15 per report, or $18 if you're from the city of Philadelphia. Hey, what's up with that? But anyway, $15. So the legislated fee schedule supersedes the right to know law fee schedule, and you can charge the $15. Okay. Earlier I mentioned that police incident reports are not considered public records. Because it's not a public record, the right to know law fee schedule does not apply. So if you choose to release the police incident report, you can charge whatever you believe to be a reasonable fee, okay, above and beyond the right to know law fee schedule, because it's not a public record. Okay, you see how all this fits together, how all this works? Maybe not, but it allows you to charge more in these specific situations where you have either a legislated fee schedule or no fee schedule at all for what otherwise is not a public record. All right, so moving on from costs, well, we're at the end of the presentation, a little early. If you have questions, now's a good time to get them in before we finish up here. I've periodically been mentioning this website, the Office of Open Records, openrecords.pa.gov. You know what's coming if you've sat through another one of these webinars. This is the best government website you will ever encounter. Why? Well, it has a wealth of resources that are updated 6 days a week. Okay. Every morning, new case file information is put up, training opportunities, any court cases that have been issued related to the right to know law or the Pennsylvania Sunshine Act, which is basically the open meetings law. There's a guidebook for law enforcement. Okay, everything that I've talked about here today is summarized in a law enforcement guidebook, which you can download for free. If you happen to be one of those AOROs, Agency Open Records Officers, there's also a guidebook available for you. It's 78 pages. Again, you can download it for free. Has all kinds of useful information in there that will help you in managing your public records. Okay, so you want to take a look at that. Other training opportunities, I mentioned the PowerPoint files, the recordings, so forth and so on. I just want to encourage you to take a look at all that. If you're a real geek about government transparency, you can subscribe to our Twitter feed. Every morning at 7 a.m., we will wake you up with a tweet with all the information fit for the day about government transparency. Okay, and you'll know what's going on in the world of government transparency by following our Twitter feed. Or, if you need to call our office, there's the phone number. There's also email accounts available on the website so that if you do have a question, feel free to reach out to us. We have administrative staff who can usually get you headed in the right direction. If not, they'll escalate your call up to senior management and they'll get back to you usually within a day because we figure it's something important and there's a deadline. You need information, so we'll help you out and get you steered in the right direction. Now, we can't answer your requests for you. We can't write requests for you. We can't talk about the substantive issues related to an active appeal. But again, we can try and steer you in the right direction and help you out with procedural issues. Okay, so I haven't seen any other questions pop up, but I do want to thank you for your participation today. We'll see you in 2 weeks where I think we're going to be talking about basics of the right to know law. Feel free to join us then. But enjoy the rest of the day. Stay dry with the storms in the forecast for later this week, and stay safe. Okay. Thanks again. We're going to log off now.